Good morning and welcome to the monthly webcast presented by the Pro Bono Partnership of Atlanta. My name is Brian Stillwagon. I'm an attorney at the Atlanta office of Sherman Howard. I'm a labor and employment attorney. We represent management in the topics that we're going to discuss today under the ADA, but also other issues such as the FLSA, Title VII, any sort of discrimination and harassment advice. The mission of the Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys with nonprofits in need of free business legal services. You can see here there's a description of the qualifications of an entity if they would like to become a client of the Pro Bono Partnership of Atlanta, and you can visit more, you can find more information on their website, which is listed there. The following page describes some legal disclaimers. Obviously, what we're going to be talking about today is not specific legal advice for your situation, for your entity. If you do have specific legal advice, reach out to the Pro Bono Partnership of Atlanta, talk to an attorney, but this is just going to be general guidance on the ADA. During the course of the presentation, feel free to ask questions, type those in, and they will convey those to me. That'll make it less like I'm talking to myself on a webinar and more like an interactive presentation. So we'll start with the purpose of the Americans with Disabilities Act. We're going to be talking about what the act was intended to do, what it covers, and specifically how it applies to nonprofits in Georgia. There are three main sections of the ADA. The intent is to prohibit discrimination in three different sections. The first, Title I, is going to be in different employment situations. Title II prevents discrimination in services provided by state and local governments. And Title III has to do with discrimination in public accommodations and commercial facilities, and that's going to be your accessibility issues. So we'll talk about those. We're not going to talk about them in that order. We're going to talk about them in the order that I think they're most likely to apply to your organization. In 2008, though, it's important to know that the president signed into law the Americans with Disabilities Act Amendment Act, the ADAAA. This act is very important. We'll talk about it a little bit more later on, in that it greatly expanded the definition of who is disabled under the law. And it really highlights how important the act is to employers. It essentially created one of the largest protected classes in the nation to go along with race and gender, because now with so many more people being disabled, there's this huge class, because essentially all of us have some sort of physical or mental flaw under the ADA. So it's important to know how big of a deal this is for employers. So we'll start with Title II, which is the least likely to affect nonprofits here in Georgia. But what it does is it applies to state and local government entities. That protects qualified individuals with disabilities from discrimination on the basis of disability in services, programs, and activities provided by state and local governments, departments, agencies that are part of those state and local governments, and certain commuter authorities such as Amtrak that have state and local government support. So it's intended to apply to all programs and activities and services that are provided or operated by state or local governments, but not the federal government. So it doesn't matter if you receive federal funds, if you are not operated or provided services by the state or local government, Title II isn't going to apply. There are some issues on what is a public entity. There are going to be some providers such as libraries, museums, volunteer fire departments that it may be unclear whether it is a public entity. So some of the factors that you look at to see if Title II may apply to your organization is whether you're operated with public funds, your employees are considered government employees, whether you receive significant assistance from the government, and whether your board is assigned by a private organization or by elected officials or voters. One note here about Section 504 of the Rehabilitation Act, that does apply to organizations that receive federal funding. So your organization may be covered by both Title II plus the Rehabilitation Act, or only one of those. So that's Title II. not very likely to apply to many of your organizations, but if you see something there that raises a red flag, then definitely seek legal assistance there. So now we'll talk about Title III, and this I think is important for nonprofits because a lot of nonprofits work in buildings that may be outdated. They may work in houses that function as offices. So we'll talk about what the requirements are under the ADA for these public accommodations. So Title III prohibits disability discrimination in the activities of commercial facilities, which are going to be non-residential facilities such as office buildings, factories, warehouses, whose operations affect commerce. It also covers private entities that offer certain examinations and courses related to educational and occupational certification. And it covers, this is the big one, places of public accommodation. And public accommodations are going to be private entities that own or operate, lease places of public accommodation. And the statute lists 12 examples, 12 different categories of what public accommodations are, and I'm not going to read them all. But they cover things such as hotels, restaurants, movie theaters, convention centers, hospitals, clothing stores, schools, daycares, senior citizen centers, homeless shelters, food banks, and other social service centers. So I highlighted some of those because they're more likely to affect many of your organizations that deal with some of those social services that are provided. An important exception is that entities controlled by religious organizations, including places of worship, are not covered by Title III of the ADA. Private clubs are also not covered except to the extent that the facilities of the private clubs are made available to customers as a place of public accommodation. So what if you are covered by Title III? What does that mean that your organization has to do with its facility? And there are a couple different categories that we'll talk about, whether it's an existing facility or whether it's going to be a new construction that your organization is going to be building. So what Title III says is that all or any portion of the buildings, structures, sites, complexes, equipment, rolling stock, or other conveyances, roads, walks, passageways, parking lots, or other real or personal property, including the site where the building, property, structure, or equipment is located, that is covered by the accommodation rules. So you know that you're covered. Now what do you have to do? If you're an existing facility, then you may be required to remove certain barriers. Physical barriers to either using the facility or getting into the facility must be removed if they constitute a barrier should the removal be readily accessible. Readily achievable. So what that means is that it's easily accomplished and easy to do without much difficulty or expense. Some examples would be installing ramps to your doorway, making curb cuts at the sidewalks and the entrances, rearranging tables, chairs, vending machines, and furniture, widening doorways, grab bars and toilet stalls, and raised letters or braille to the elevator buttons. So those are things that aren't going to cost the company much money, so that's going to be readily achievable. That's something that you'll need to do if you're in a structure that is not meeting the accessibility requirements of the ADA. But the first priority should be looking at how do we get disabled individuals through the front door. So that's going to be the ramps, widening the doorways, and then once they're in, then we can look at how they can better get around that facility. If you cannot remove certain barriers because it's not going to be readily achievable, there are some things that your organization can be required to do in the alternative. And so some examples for that is if you can't easily add a ramp, if you can't easily widen all the doorways that are going to be necessary, maybe you don't have control over the entire building. Some examples of these alternative measures would be providing goods and services at the door, the sidewalk, or the curb, so that gets rid of the necessity of them needing to get into your facility, providing home delivery, retrieving merchandise from the shelves or racks that are inaccessible, and relocating activities to accessible locations. Now, it's important to know that obviously if you do those alternative measures, you can't charge an additional fee or treat those individuals differently because you are choosing to do that as the alternative rather than making structural changes to your facility. New construction is relatively straightforward because when you go out to hire the contractors, there's obviously going to be certain codes that they're going to have to follow. So we won't touch too much on that. But if you're building a newly constructed building, then it has to be accessible to individuals with disabilities unless it's structurally impracticable, and that's a decision that can be made by the engineers and by the contractors that you are working with. If you are in an existing facility and you decide to do a remodel, if you buy a vacant house and you're going to turn it into your office and you're going to be gutting it and making renovations, then there are certain responsibilities that you have during that construction process. The alteration that you're making, for example, if you're doing a remodel and you're moving a doorway, then when you move that doorway, the doorway needs to be wide enough to meet ADA standards. So the idea is you're going to be building a new doorway anyway, so it's going to be a new construction essentially, and so it needs to meet the ADA requirements. Should this be something that your organization is going to look into do, there are some tax credits and tax deductions that are available for entities. So a special tax credit is available to help smaller employers make accommodations required by the ADA. The eligible small business may take a tax credit up to $5,000 per year for accommodations made to comply with the ADA. The credit is available for 1/2 the cost of access expenditures that are more than $250 but less than $10,250. So that's a tax credit to look into should you feel the need to make some changes. A full tax deduction up to $15,000 a year is also available to any business that is going to be removing barriers to access. So some things to look into if you need to go that route. The last title that we're going to talk about today is probably the biggest one that we see in the type of law that we practice, labor and employment, and is often ones that carries the most risk to organizations, and that is Title I, which covers discrimination in employment. So the ADA prohibits discrimination against qualified individuals with disabilities. So the first question that we need to ask is, what's a qualified individual? Meaning who is disabled? An individual has a disability if he or she falls into one of 4 categories. The first is disability, and that's a physical or a mental impairment that substantially limits one or more major life activities. So that's the easiest to understand. That's someone who is disabled. The ADA, though, also covers those who have a record of a disability or a record of that type of impairment. It covers those who are regarded as having a disability. So they may not have a disability, but if the employer regards them as having a disability, then they too are covered by Title I of the ADA. The final one that isn't discussed that often, but it makes some common sense, is association disability, and that's you cannot discriminate against employees who associate with someone who is disabled. So the disabled person is protected, but if he or she is married to a disabled spouse, you cannot discriminate against the non-disabled employee because of their association with the disabled employee. We mentioned ADAAA, the Amendments Act, and in 2008 when that was passed, what that did was that expanded the definition of disability. And I'll give you 2 examples of how it did that. The first was, so we talked about disability as a physical or mental impairment that substantially limits one or more major life activity. Well, the ADAAA said that major life activity no longer means something that is central to a person's everyday life, such as eating, sleeping, breathing. It can be much smaller activities that aren't crucial to living, but are a major part of your life, whether it is driving or anything along those lines. The ADA also says that we no longer consider mitigating circumstances. And so what that means is you look at the disabled individual without the assistance of devices to help them with their disability. 2 examples. One would be you look at a diabetic employee as a diabetic without insulin. You don't look at whether they're disabled using insulin. You also would look at a paraplegic without the use of a wheelchair or without the use of a prosthetic. You look at them as a quadriplegic without those mitigating techniques that they're able to use. And so that's going to greatly expand the definition of who's disabled. So to whom does Title I apply? And this is important because some nonprofits are not going to be covered by the ADA because they do not employ enough employees. And so Title I of the ADA covers private employers with 15 or more employees. This includes state and local governments, but also applies to employment agencies and to labor organizations. It's important to know that while it covers employees and those who are applying to be employees, it does not cover your independent contractors. That's a whole nother presentation in itself. If you have independent contractors, take a look at the Pro Bono Partnerships webinar on the independent contractors to get that straight up. We have a quick question.
When you say 15 employees, is that 15 full-time employees or just 15 people employed by the organization?
Under the ADA, I believe it's going to be full-time employees, but I can definitely check on that, and we can post that. We can post that later to see, because I know it does change depending on some of the acts. Some of the acts look at part-time, and the part-time can make up full-time employees. For example, if you have 2 part-time employees, that equals 1 full-time employee. But we'll get some clarification on that and post that. Okay, so we know who Title I applies to, but when does Title I apply? Title I prohibits discrimination in any tangible employment action. So that's going to be the job application procedures, hiring, firing, promotions, compensation, training, or any other terms and conditions of employment. So it's not just that it prohibits discrimination if you fire someone. It's if you refuse to give them a promotion, you refuse to send them to some sort of special training that you would send a non-disabled person to. So it's any terms and conditions of employment. What about exclusions from the ADA? What disabilities are not covered? And the ADA has a few statutory categories that are specifically excluded from protection, and you see 4 of those here. Transsexualism, compulsive gambling, kleptomania, and pyromania. For whatever reason, the legislators just said, we're not even going to fight about whether these are disabilities. They are not covered under the ADA. But what about drug users, which I know many of the nonprofits try to help and rehabilitate? Drug users who currently engage in the illegal use of drugs are specifically excluded from a qualified individual with a disability protected by the ADA. So if one of your employees is currently using illegal drugs, they are not protected by the ADA. There is that should be distinguished, though, from someone who comes to you and says that they are addicted, they have a problem, and they would like to take some time off to get treatment. That individual does have protection and does have the right to take time off under the FMLA or under the ADA to go get treatment for that problem. But again, that doesn't cover current users who are affected at work unless they come to you first and say that they're trying to seek help. The employers may conduct drug testing, both of their employees and their applicants, and make decisions based on those results. And so if the results of a drug test reveal the presence of the illegal drug, then obviously they are not protected by the ADA. If a lawfully prescribed drug comes up, or you discover some sort of other medical information, then that information must be treated as confidential medical information. What about alcohol? What if you have alcoholics, if you have an alcoholic on the payroll? Someone who currently uses alcohol is not automatically denied protection. So an alcoholic is to be distinguished from a drug addict. The alcoholic is not automatically denied protection. The person is denied protection if the alcohol problem becomes a problem at work. If someone shows up drunk, if the alcohol is affecting their work activities, but someone who is an alcoholic outside of work, who drinks outside of work, is protected by the ADA. That means that an employer may be required to provide an accommodation to an alcoholic. If the alcoholic needs to take time off to go into rehabilitation, then that is an accommodation that is likely going to be reasonable and required of the employer. But of course, the employer can certainly prohibit the use of alcohol in the workplace and can require that its employees not be under the influence of alcohol when they come to work. This is also coming into the news lately as marijuana becomes legal in several states. For example, in Colorado, just because it is legal in the state does not mean that you have to allow your employees to come to work high. Obviously, it's the same thing with alcohol. If they come to work under the influence and that's a violation of your procedures, then you can discipline them and terminate them accordingly. Okay, so you have a disabled individual. What are your requirements, responsibilities as an employer? So if an applicant or an employee requests a reasonable accommodation, that triggers the interactive process, which is an informal process in which you as the employer need to determine the limitations caused by the disability and what some potential reasonable accommodations would be so that that employee can overcome the limitations. Again, the ADA is not meant to treat disabled employees better than non-disabled employees. It's to treat them the same and to give them the opportunity to perform the same job that a non-disabled person would be able to perform. Don't seek out a disabled employee and ask them if they need an accommodation. It is the employee's responsibility to ask for a reasonable accommodation. You can get yourself into trouble by asking if they need an accommodation, and they might not really be disabled, but all of a sudden you regard them as being disabled and trigger protection under the ADA. So it is their responsibility to seek a reasonable accommodation. However, that request for a reasonable accommodation doesn't need to be very formal. It doesn't need to be written. So it's important for you and some of your first line managers to know what to look for and what triggers the request for a reasonable accommodation. There are not going to be any magic words. They don't have to say, I'm coming to seek a reasonable accommodation under the ADA. For example, let's say you have an employee who has a medical emergency due to MS, who is hospitalized and requires time off. That is a trigger for a reasonable accommodation, the accommodation being time off for the hospitalization. You have an employee who's out with a workers' comp injury. He or she is released to return to work with certain limitations. Those limitations, that's the trigger for a reasonable accommodation. Can you accommodate these limitations? So that's important to look out for. You don't need to go to them to find out what reasonable accommodations they need, but once you hear that they are requesting accommodations to do their job, that's going to trigger the interactive process to start to talk to them about what you can do to help them perform their job. The next page here, once you have a disabled employee who says that he or she can't perform the task and needs an accommodation, that's when you should start to ask them questions about, okay, what can we as the employer do to help you do your job? If the employee says that the only way that I can continue doing my job is to stop this certain aspect of my job, cease doing a function. If that is an essential function of that position, for example, you have an assembly line worker who says, I can no longer work on the assembly line. There's no accommodation that you could give me that would help me do that job. I can't do that part of my job anymore. Then that's an unreasonable request, because the idea is that the employer has to give reasonable accommodations, and a reasonable accommodation is one that enables the employee to perform the essential functions of the job. And if the request is to not perform one of those functions, that's an unreasonable request, and that ends the process. If the employee requests to stop performing a non-essential duty, for example, something that you could easily ask another employee to do that's not going to put a big burden on that employee, it's not going to reallocate a lot of resources, then you can look at restructuring the disabled employee's position to make that work. But again, you're looking at non-essential duties, and so it's important in your job description to list exactly what those essential duties are and what the non-essential duties would be, and make sure that it is realistic, that if you list it as an essential function of that job, then the employees in that job are actually performing it, and if they don't perform that, you would have to find somebody else. If you have a job description that's outdated, or if it's inaccurate and has essential functions that aren't truly essential, that's going to be a big obstacle to overcome should we need to rely on that defense down the road. You are not required as the employer to use the employee's preferred accommodation. Just just an accommodation that's reasonable. So if the disabled employee comes to you and says, this is the accommodation that I would like, if there is another reasonable accommodation that would have less of an impact on your business, and it's still a reasonable accommodation, you can choose that accommodation. You don't have to defer to what the employee wants. So for example, if the employee wants to work from home to do his or her job, if there is a way, because of the lighting in the employee's office, if you can also change the lighting in the office, put in additional shades, you can add a dimmer, that would also be a reasonable accommodation. And so therefore you don't have to allow the employee to work from home just because that's also possibly a reasonable accommodation. Last point here, don't question the employee's disability. Like we said earlier, with the expansion of the ADA, we're all disabled. We all have a disability. And so if someone is coming to you claiming that they are disabled and it sounds legitimate, go through the interactive process, leave the dispute over whether the person is actually disabled to your attorneys should a lawsuit come up, because that's not the appropriate place to deal with it when you're in the workplace dealing with an individual who is claiming that he or she is disabled. One final point on that, documentation. Document everything. Document the interactive process. When an employee comes and asks for a reasonable accommodation, keep track of the conversations, of what accommodations were proposed, and what you're actually carrying out. Being able to point to the process and that the employer went through that process with the employee would be a great benefit should litigation ensue. So we discussed here what a reasonable accommodation is to get the employee to be able to perform the essential functions of the job. Here's some examples that the EEOC list as possible reasonable accommodations, ones that are common. Schedule changes, swapping marginal functions. So again, those are the non-essential functions. Telecommuting, policy modifications, reassignment to a vacant position. So there's no requirement to form a new position for the employee, but if there is an open position for which the employee is qualified, then you may need to look at that person applying for that job. And finally, obviously, time off for treatment or recuperation. You know that under the FMLA, it's the same way with the ADA. People who try to take advantage of these protections often want time off. That's the accommodation they want. And so just go through this process, because obviously an extended leave of absence or time off does not enable them to perform the essential functions of the job, and so that may not be required under the circumstances. But again, seek legal counsel for the specific situation. Here is leave as an accommodation. Some employees may request a week off because they need to have some sort of surgery. That's obviously going to be much more realistic and reasonable than someone who needs months and years off and doesn't have an idea of when he or she is going to return. If the employee does not know when he or she might be able to return, and you try to go through the process with them to learn when that might be, or they keep extending their leave, there's going to come a point in time where you as the business likely need to have someone to do that job. And so the advice that we often give after all of the FMLA is extended and that time is used up, your short-term disability, any PTO and vacation, if the employee doesn't know when he or she is going to be able to come to work and it seems like it's an uncertain and indefinite leave, then we say to not terminate the employee. You can keep them as a technical employee, but replace the employee, especially if the position that person is supposed to be in is crucial to the organization. The organization can't really move forward while that person is out on leave. So replace the individual, and if a year or two down the road the disabled person says that they can now come back to work, then they're free to apply for any open positions that are there, but you as an organization have had to move forward. Because again, the unreasonable request was the indefinite leave. Now this is in Georgia, this is in the 11th Circuit. Obviously if your organization is in California and elsewhere, then the advice is going to be a little different. second to last slide here that we'll talk about today are if you have disabled applicants and some of the accommodations that you might need for folks in the hiring process. So we've talked about the employees that are already on your payroll. What about those who come in and apply? You may need to provide written materials in accessible formats such as large print, braille, or audio tape. You may need to provide readers or sign language interpreters. You need to ensure that recruitment and test and interviews are held in accessible locations so that disabled individuals have the same opportunity to apply as non-disabled. You can adjust the application policies and procedures. The employers must only provide an accommodation if it's reasonable and does not need to provide the accommodation if it causes an undue hardship. And so even if it is a reasonable accommodation, one that would enable the employee to perform the essential functions of the job, you don't need to do it if it is going to require significant difficulty or expense. We encourage employers not to worry about the undue hardship because it's going to be very hard to win that if it goes before a court, because the court's going to look at the organization and say, surely you could have spent this amount of money to make it worth the employee being able to use the reasonable accommodation. So instead, shift the focus to is the accommodation reasonable? Does the accommodation that they are proposing, that you are proposing, allow the employer, the employee to perform the essential functions of the job? Some prohibited questions during the hiring process are any questions that are likely to reveal the existence of a disability before you make a job offer. So for example, a written questionnaire, questions that you ask during an interview, medical examinations, things that target or that reveal whether the employee may be disabled are going to be prohibited. Some examples: do you have a heart condition? Do you have asthma? Do you have a disability that would interfere with your ability to perform the job? How many days were you sick last year? Have you ever filed for workers' comp? Have you ever been injured on the job? Have you ever been treated for mental health problems? What prescription drugs are you currently taking? Those questions, if answered, could reveal the existence of a disability and will automatically make it a really tough case for you should you make a decision not to bring that person on because it's going to look like you did so because you found out about a disability. Once you extend a job offer to the individual, then you may ask some of those questions as long as you ask the questions to all of the applicants. You can't ask them to the person who seems like he or she might be disabled. You can ask those types of questions if you ask them to all your applicants. Similarly, you can require a medical examination once you make the job offer, as long as you require the medical examination of all your employees and not that you're just selectively picking out. So that's the ADA. So the final slide here talks about what happens if there's a violation. Particularly, we'll talk about Title I in the employment. If an employee or an applicant brings a claim that you have violated the ADA, their first step is to go to the Equal Employment Opportunity Commission, which is in charge of enforcing the ADA Title I. A charge of discrimination has to be brought within 180 days of the act that they are claiming was discriminatory. So for example, you terminate someone, the employee has to bring the claim to the EEOC, file the charge within 180 days. The EEOC then investigates. They will likely have the employer file a position statement saying, why did you really terminate this individual, to try to determine whether there was a legitimate non-discriminatory reason for the termination. The EEOC has also been much more aggressive in doing on-site visits and looking at company documents and talking to company witnesses as part of their investigatory role. The EEOC at that point, at the conclusion of their investigation, can issue a finding of cause that they think there was discrimination. No cause, they don't think there was based on their investigation, or they're unable to determine whether there was discrimination. Regardless of their finding, they issue a notice of a right to sue, so that employee then within 90 days has the right, regardless of what the EEOC found, to file a lawsuit in federal court. They must go to the EEOC administrative process first before they can file a lawsuit. Should there be a finding that there was discrimination, remedies can include getting the current employee the promotion that they think that they were denied. If it was an applicant, they can be forced to hire the individual. If they were fired, they can be reinstated. They can get back pay for all of the lost payment that they got during that time. And often one of the largest chunks of money comes from you have to pay their attorney's fees. So that's what's at stake here. That's why it's such a big risk for employees to make decisions based on disabilities. The ADA is there to encourage companies to hire disabled individuals that can perform the essential functions of the job just like anyone else who's not disabled. And if you have any other questions about any of the titles here, then I encourage you to reach out to Pro Bono Partnership. And with that, I'll see if there are any other questions. All right. Thanks so much.